Case of People versus Stephen Ruggs.
She just walked out.
Ms. Julian, if you see Ms. Solana Reed on the way out, please let her know we're waiting on her.
Yes, sir. She just walked out.
Sir, if you do me a favor and step to that side, thank you.
Good morning, Sylvana Reed, Assistant Public Defender, with and on behalf of Mr. Ruggs.
All right. This is going to be a waiver.
That is correct.
Mr. Ruggs, you signed this examination waiver?
Yes, I did, sir.
You understand that the preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
And you understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following. Street.
Thank you. We would acknowledge receipt of the information, waive any further reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
27th at 1:30 for Judge Slate Thursday.
June 27, 2024, 1:30 Slate Thursday. Bond with its conditions will continue. Yes.
The note in my file from the other APA that you saw violation you have today.
Yes.
The May 17, 2024 bond violation report.
I do. Is there a reason why you were missing? You were testing elsewhere, weren't you?
No, sir. I was told I needed a court order, and I was on video Zoom with you on my last court order, and nobody contacted me and told me where to go.
Why didn't they?
I do have information about a facility that he would like to test at. He lives in Macomb County. We
I'm on GPS.
called them, and they indicated as long as the order indicates what sort of panel he's testing and the frequency.
Well, that was supposed to be done before. If I give you a test today, are you going to test?
You know, the only thing I'm going to fail for would be marijuana.
Why are you using that?
Can I speak freely?
Yes.
Your Honor, I'm going to be up honest with you. I used to have crack cocaine addiction, and I've come a long way. I've been through a lot, this past few months. I lost my father, my grandmother. And there's no excuses. It's just the only thing that I've up there.
Give me an order. Okay, he's going to go over to community corrections test today. I'll get the results, and then I'll determine what his bond will be as he proceeds up. Because he's told me what's going to happen, and then we'll figure out. In the meantime, counsel can prepare an order so they can test in Macomb.
Okay. And then just to be clear, the record, the waiver is complete, and we're only coming back on whether or not they'll be granted.
Pardon?
The waiver's all set now.
Well, technically, no, because technically to retain jurisdiction, but I still have jurisdiction anyway. So he needs to go over and test, and then we'll figure out what we're going to do.
Okay. Thank you.
Thank you.
Remind me, 'cause I'm doing it one time on that one.
Okay.
But then when I complete it, I'm going to have to put it back on whatever I had. Right? Yeah. What was that on? Coming back in. Oh boy. It's gonna be that day. She said you're on there, and then what's wrong?
I'm just very surprised.
Yeah.
The file's still in the courtroom, correct?
Pardon?
Is that file still in the
No,
courtroom?
it's sitting here right with me.
You can recall it whenever you have the opportunity. That'd be wonderful.
Why not? Court recalls case. People versus Ruggs.
Thank you, Your Honor. Nicole, please on behalf of the people.
Sylvana Reed, Assistant Public Defender, with and on behalf of Mr. Ruggs.
As we were walking out of the courtroom, I went to release the deputy who was present. I did not believe that the victim of the domestic violence was present today because she didn't check in with us. As we were leaving, the deputy let me know that the victim was actually present today with the defendant sitting beside him. As we exited into the hallway, so that I could see who the deputy was referring to, the defendant was speaking to Ms. Perkins out in the hallway, and the deputy confirmed that that is the victim. There, as I understand it, based on everything that's filed, there's no contact with her. In that, in addition to the corrections violation, I'm requesting that he be remanded and that it's not be revoked.
That's not my problem.
Mr. Allen, thank you, sir.
Your Honor, I have no further information at this time.
Does he admit to the violation?
Last week,
If you wish.
she wasn't here with me today. Your Honor.
Were you talking to her in the hallway?
She made a comment to her in the hallway. We were talking to her about testing, and I said something I didn't.
Were you sitting next to each other in the courtroom? You know I can get video from the courtroom.
Okay, I
So
understand. Yeah, she was sitting next to me.
you're not to have contact with her. You know that. Forget the testing. Defendant's bond at this time is revoked. Defendant's remanded. Get this go up before Judge Slay. I'll just leave it there.
Thank you.
Your Honor.
No. They got one at the door, not one I sent. Okay. Just getting weird. Court does call the case, People versus Emmanuel Henry. You can have a seat right there. Is Miss Gaines around?
I've seen her.
That's probably, I'm just trying to, so you have a file.
This is the plate. Both out. This is a waiver. Mr. Henry's a waiver. Is that what you're doing? Mr. Henry's a waiver.
Yes.
So we can get an attorney in here for him. Were you speaking with somebody today? She was here. Okay. I hadn't seen her today, so I wasn't sure. Next over, she, Miss Lundy, if you see Miss Gaines, can you?
I have seen her this morning. I'll go check her later.
You're better than me. I haven't seen her this morning. Seriously, anybody from the public defender's office. I'll take it. Yeah, find somebody. It's, from my understanding, it's a waiver. I don't, no, it's not. Okay. And I'm wrong. Well, that's what we had heard, but I don't know. Brendan is shaking his head no.
This is indicating she's not what she's. Join the scene is a public defender. Okay, all right. Your Honor, we were initially going to waive the preliminary examination.
That's what I understood. That's what I understood, but
Yes, this one, my friend is indicating that he no longer wishes to waive.
okay. So what are we gonna do? We're gonna have it.
We are ready to.
Well, he's gonna have to go back because I'm gonna handle these other matters. I brought it out because I thought it was a quick matter. So take it back. Gonna do these.
I missed her.
Yeah, no, we found her.
Good.
So she was as surprised as me. I'm why?
Can you go to the next one? It's already told us.
Court calls the case people versus Howard Smith.
Your Honor, he was here.
Oh, man.
Oh, no.
Well, let me, let's just say this is a similar situation to one you had about 3 cases ago, where he was going to be sent across the street.
And so he,
Proactively went and did it on his own.
Oh, I think, absolutely, yeah. No question.
so he's not here.
Well, let me go out in the hallway and see. He was here. 'Cause
Go ahead. You can check away. It's just one of those days.
I think he's over there testing away.
You think so? Okay. I love the faith that Mr. Childers has in people. Oh, I think he's gone. I think maybe at the nearest beach he could find. He is gone. But it's attorney's day.
I stuck around.
Yeah, I know.
He's not, he's gone. David I. Goldstein, bring on behalf of the defendant. Yeah, I told him there was a community corrections violation. Discussed it. I asked him if he was going to test dirty. He said probably for marijuana. So,
So for marijuana, he left. Yep. Preliminary examination being set. Defendant having failed to appear, bench warrant will issue for the defendant's failure to appear. I will indicate defendant was here and left. Will issue immediately, no bond.
Maybe he's.
No, Mr. Childers, leave it alone. Yeah, maybe a lot of things happen. Right. So
Here's Mr. Patel. That's where we always want it.
has he signed any advisory rights? Pardon? I'm sorry. Tell on your case, has your client executed any advisory rights?
I don't believe so. The result are pretty quickly.
Okay, so I need him to sign an advisory rights.
That take care of now.
And I'm going back and start again. Yeah, because this got weird fast. Here we go. Now we're talking. Oh my God.
Whatever you want. Whatever you want.
Where do we talk about? Seriously? Yeah, that is it. Here we go. Court calls the case, people versus Theophilus. Yeah, let's get him out. So.
Oh, you're on. Okay. You, the file for Mr. Howard Smith's gone
Oh, yeah. Why?
because I just got a text from him.
He's
I want-
testing?
I want texting. Not sexting, texting.
Thanks for clearing that up. Okay, you got a text?
Don't you?
Yes. Hold on one second. I- Okay. Court calls the case People versus Theophilus.
That's all I can people.
David Eichholz, appearing on behalf of the defendant.
Theophilus Smith.
Your Honor, today's date time set for preliminary examination. Unfortunately, Detective Van Alstine is not present. He's on leave, and the domestic violence victim is also not present. So requesting adjournment.
Your Honor, Mr. Smith, just be quiet. Okay. Your Honor, as both this court and Ms. Lundy know, I'm generally very amenable. I'm very flexible because we all work together and try to get these things moving along. This is one time I am going to have to object, however. I've only been in this case since November, and I understand that a lot of the delays were not occasioned by either the people or Mr. Smith. We were waiting for the forensic center, and for whatever reason, they really dropped the ball. Well, I guess that's not unusual these days. So then we withdrew the request for the referral. The court set this for exam on on April the 25th. So this matter has been set for almost a month now. And I'm not blaming Ms. Lundy, she knows that. But this matter should have been either should be ready to go, or I should have been notified prior to today. This isn't like Van Alstine got sick this morning or had an accident this morning. If he's on leave, somebody should have known that. And that should have been dealt with. And not only is he not here, but the complainant isn't here either. So I'm going to object.
You still have a place on Miller?
No,
No, no longer. Okay.
I lost my place, Your Honor.
Got it. If you were out, where would you go?
To my mother's house,
Where's that?
Swan Creek. Hams Lane.
Is that the 6988 McKean?
Yes, sir.
6988 McKean, lot 262.
Got it. Okay. Is this the only case holding him?
Yes, Your Honor. As far as my knowledge, yes.
Here's what I'll do. I will grant the people's request for an adjournment to June 11th, 2024 at 9 a.m. However, what I will do is I will reduce the defendant's bond to a $50,000 personal recognizance bond. However, prior to his release, the defendant will be fitted with a GPS home confinement tether, where he'll, I guess, be at his mother's home, but he'll be confined to the home until this exam is concluded.
Thank you, Your Honor. I just want to make sure I heard June 11th.
June 11th.
Thank you, Your Honor.
Yes, sir. All right. You understand that, sir?
Yes, sir. You said PR?
Yes.
Well, it's a PR, but you're going to have a tether and you're going to be confined to your mother's home
Okay.
until you get back here for exam. Understood?
Yes.
All right. All the other conditions that were set still apply, sir.
I discussed the no contact with him, Your Honor. I think that's what the court's.
Yes. Huh? Yeah, right there. Okay. Court does call the case. People State of Michigan versus Reginald Harris.
Good morning, Your Honor. We're both bringing on behalf of people.
And good morning, Your Honor. Assistant Public Defender, Fellow Patel, on behalf of Mr. Harris, who stands to my right.
In this matter, I have a plea form before me that indicates the defendant will be pleading no contest to the charge of aggravated assault, the one-year offense. Upon a successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
May I have it sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name. Reginald Harris.
All right. Sir, it is this court's understanding that you're going to be pleading no contest to the charge of aggravated assault. That's a misdemeanor punishable by up to 1 year incarceration and or $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. I also have to, do you understand what a no contest plea is? Okay. Well, let me explain a couple things about a no contest plea. The first thing you need to understand about a no contest plea is the court has been provided and has reviewed the police report in this matter, and I would take those facts and accept them as true to determine whether or not this offense was committed. You understand that? The other thing you need to understand is that it means a no contest plea that you're not further desirous or wanting to contest this charge. You understand that?
Sure.
The other thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty to this offense. You understand that? You understand that, sir? Okay. I also have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour at the 14A4 District Court. You understand that?
Yes.
All right. Any other questions you have about a no contest plea? No? All right. Sure to tell us the basis for the no contest plea.
Civil liability.
Sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any question about any of those rights?
No.
All right. On the podium, please look, you'll see a copy of one. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yeah.
Are you on probation or parole?
No.
Anybody promise you anything other than what's been stated here today, which is actually, other than what's been stated here today, to get you to plead no contest?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
Because you, well, I won't answer that. Counsel, I have been provided Washington County Sheriff's Office report for their case number 22-104113 and have reviewed same. Any objection to the court having reviewed that report?
No objection, Your Honor.
Based upon a review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt of the defense counsel. Have I complied with the court ruling? Would it be proper to accept this defendant's plea?
You're satisfied. Thank you, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4. Probation sentencing in this matter will be
July 2nd at 9 a.m. before Judge Rush Hour.
July 2nd, 2024, 9 a.m.
Yeah.
9 a.m. before Judge Fresh Hour. Found in this matter will continue. Thank you.
If I can I request him as my lawyer on the second?
What?
Can I
Request him as your lawyer?
Yeah.
I wouldn't want him. Why? Why? You really want him again?
Yes,
Really?
yes,
Seriously?
seriously.
I never heard that before about him.
Yeah, they say it's the first time for everything.
Yeah, I guess so. I'm shocked. Write this down. We actually have somebody that really wants him.
He's a good lawyer.
He is?
Yeah.
Yeah. But nobody wanted him, almost like an orphan. What?
I do.
You do?
Yeah.
Okay, well, until he found a home. Sorry, that way, I joke. He is a very fine attorney, and Washington County is really fortunate to have him present now in this county as part of the public defender's office. The assignment of attorneys, however, is not up to me.
Oh, it's not?
Okay.
Oh.
I do know the person you can call to make it happen, but I ain't gonna say.
Call.
No. All right. Take care.
All right.
Mr. Brown. Oh, yeah. Here. That's the chief deputy. Public defender. He wants Odetella to represent him on the sentencing. I told him I didn't have anything to do with it. And then, okay, I don't know why he wants Odetella. That's fine. But he was trying to find the person that could make it happen. So Brown, go ahead. But if you let the man down.
Okay, come on.
Brown, you let the man down. You could have done better than that. Wow. I'm hurt now. Mr. Odetella's gone now.
Shut another one, don't worry, he'll be back.
No, I don't want it back. I just said I'd make it really sympathetic.
This one they're holding.
Who's holding?
Okay, this one, bring Mr. Johnson.
They're holding.
Yes.
Okay, so they're holding. Oh, sorry. I'm gonna take a break, but I got it.
This one is holding as well. This
How many
one,
witnesses do they have? This one? 2? Okay.
that's 3 witnesses.
Okay.
This is oh, this is Mr. Emmanuel. That was in the way within 1, so.
Okay.
This one I believe is gonna be a plea, I have no paperwork. Yeah.
Who's on it?
Mr. Emmanuel's for it.
Oh, yeah. Okay. Give me a minute. I got 4 potential. Right? Okay.
Yes, correct.
All right. Court's gonna stay in recess.
All right.
How many are you? Everybody.
Yes, everybody.